Hi guys, good evening and welcome back to Gradeup. My name is Harshmeet Singh and you're watching me live on the YouTube channel of Gradeup IAS. I hope all of you are doing good and I hope all of you attended the last class yesterday also. As you know, this is a mini series in which in 5 topics I will be covering your entire higher judiciary for the IAS examination. In the 5 classes, that is from Monday till Friday, we will be completing everything about the Supreme Court and the High Court that is necessary. So I hope that you have attended the last class. Yesterday we had discussed about the Supreme Court appointment of judges and the Supreme Court removal of judges. Today we will be discussing about the jurisdiction of the Supreme Court. Next we will be discussing about the High Court. Then we will be discussing about why are so many cases pending in the judiciary. And in the end we will be discussing about the concept of the PIL, and it is the concept of curative petition as we see in India. That is what we will be doing in these 5 lectures. So do make sure that you attend these. Good evening to all of you. Yes, Manish, you do come every day. So good evening. Hi, Pranal. Good evening. Good evening to all of you. Those who have come in, do hit the like button. Do hit the subscribe button also. And make sure you attend all these classes from Monday till Friday because that is where we will be covering the entire topic as we see. So today we will start with the jurisdiction of the court and we will be seeing what are the kind of cases that the Supreme Court can hear. What exactly is the power of the Supreme Court? What is the scope of the power of the Supreme Court? Now, Supreme Court has different types of jurisdictions, means different types of cases are heard by the Supreme Court. First kind of jurisdiction is the original jurisdiction. Original jurisdiction means what are the cases which start at the Supreme Court level only. The cases which will start at the Supreme Court, for which you don't have to go to any lower judiciary, but you will start from the Supreme Court, like center versus state, center versus one or more than one states, center and one state versus the other state, any case between two states, let's say Maharashtra versus West Bengal, Punjab versus UP, state versus state cases. All these are cases where Supreme Court has exclusive original jurisdiction. Means these are the cases which exclusively can only be heard at the Supreme Court level and nowhere else. There are some other cases also which can only be heard at the Supreme Court level. For example, if there is an election dispute in the president or the vice president election. So election dispute of president, vice president election, that also can be heard only at the Supreme Court level and nowhere else. These are exclusive jurisdictions that cannot go to any other court. There are some other cases that you can bring to the Supreme Court originally, like if your fundamental right is violated, you have the right to approach the Supreme Court directly, but that is optional because in that case you can go to High Court also. However, these things that we just studied are exclusive jurisdiction, means these cases can only and only come at the Supreme Court, they can start at the Supreme Court only and nowhere else. We also have this misconception in our mind that any case can come to Supreme Court. No. There are some cases which cannot come to Supreme Court also. What are those cases? If there is a dispute related to any pre-constitutional treaty. So there's a dispute about a treaty that was signed before the constitution. Now, how can a treaty be signed before the constitution? That is, when India was ruled by the British signed many treaties on behalf of India. So if any treaty was signed on behalf of India by the British, that is a pre-constitutional treaty, those treaties also cannot be challenged in the Supreme Court. Not just this, any other dispute from a treaty that specifically says that this should not go to the Supreme Court, then obviously you cannot take it to court. Let's imagine that India and America signed a treaty in which we wrote, or let's say India, we are taking vaccines from Pfizer and we signed an agreement. In the agreement, we wrote that if there is any problem about this contract, you cannot go to the Indian Supreme Court. If this is written in the contract, then obviously then you cannot go to the Indian Supreme Court. So any treaty that specifically says that Supreme Court cannot be approached, obviously you cannot approach the Supreme Court for that. Not just this, there are some other matters also for which you cannot approach the Supreme Court. For example, interstate water dispute. For these, special tribunals are formed. Any matter related to Finance Commission, yeah, as you know, Finance Commission is a constitutional body. They give their report once in 5 years. If there is a matter regarding Finance Commission, no, again, it cannot be challenged. If there is a matter about adjusting expenses and pension between center and the state, again, cannot be challenged in the Supreme Court. Commercial disputes between center and the states cannot be challenged. For example, the state cannot go to Supreme Court saying that center had to give us the money, they have not given us the money. No. That again is not allowed. Not just this, recovery of damages also cannot be done by a state against the center. So the state government cannot say that the central government is not paying us money, they have caused us so much destruction, or they have caused us so much loss, we want money from them. No. That again cannot be done. All these things cannot be challenged in the Supreme Court of India. So this should not be in your mind that any case can go to Supreme Court. No. There are some cases in India which cannot go to the Supreme Court. The next type of jurisdiction the Supreme Court has is the writ jurisdiction. Writs are orders that the court issues to bring back or to give your fundamental right to you. If your fundamental right is violated, you can approach the Supreme Court and ask the court to issue writ. Writ means orders of the court to restore your fundamental rights. The Supreme Court can issue 5 types of writs, that is habeas corpus, mandamus, prohibition, quo warranto, and certiorari. Let me try and explain what are these. Let's say first is habeas corpus. Habeas corpus means if the police or any government authority has illegally detained a person. So if a police or a government authority has illegally detained a person, against that the court will issue habeas corpus. So again, habeas corpus means that we will have a public authority that has actually arrested someone without the authority. They should have told the magistrate. That is when the court will issue habeas corpus. So habeas corpus means if someone has been detained illegally, the court will order to issue them. Next is mandamus. Mandamus means when a government official is not doing its duty properly. When the government is not doing it, when the government official is not doing its duty properly, against that government official, mandamus is issued. That is an order to ask them or to tell them to do their duties properly. Next is prohibition. Prohibition and certiorari are very similar. Prohibition and certiorari are issued by the lower court, that is the Supreme Court, by a higher court against a lower court. The Supreme Court can issue this against a district court. When the Supreme Court thinks that the lower court is hearing a matter beyond its jurisdiction. The difference between two is prohibition is issued when the lower court has not given the final order. So to stop the lower court from hearing the matter further, that is when prohibition is issued, to stop the lower court from hearing the matter any further. Certiorari means lower court has already given the order. So the higher court is cancelling that order, putting a stay order and giving a new order. This is called certiorari. The last writ that Supreme Court has is quo warranto. Quo warranto is issued against a public official when the officer is holding an office which he or she is not eligible to hold. If a public official is holding an office, let's say beyond the retirement age, even if he has been disqualified, he's still in the office, then against that person, quo warranto will be issued. So these are the 5 writs that the Supreme Court has. Supreme Court also has appellate jurisdiction, means it is the highest court of appeal. After the High Court, if you are not satisfied with the order, you think that injustice has been done, you can appeal to the Supreme Court. Now, you can appeal to Supreme Court in all the constitutional related matters, civil matters, criminal matters, and also appeal by special leave. What exactly is appeal by special leave? In political science, the word leave means permission. So what we mean to say is, if there is a case against you in any court of India, let's say in a lower court there is a case that is against you. If you think that justice has not been done or you will not get justice, you can write a letter to the Supreme Court requesting the court to please transfer the case to Supreme Court. And if the Supreme Court thinks that they want to do it, they will transfer the case. This is called appeal by special leave. And if your case is in any court of India, you have the right to appeal in the Supreme Court, request the Supreme Court to please transfer your case. If they think it is a legitimate matter, yes, it is important, they will transfer your case. This is called appeal by special leave. It depends on the court whether they want to transfer this case or not. Then there is advisory jurisdiction under Article 143. President of India has the power to ask for opinion of the court in legal matters. That opinion is not binding on the president. Okay, whatever the Supreme Court says is not binding on the president. Also, so the question can be about a law or a fact of public importance. However, in this case, Supreme Court can also refuse to answer. The Supreme Court can refuse to answer. On the other hand, the question can also be about a pre-constitutional treaty. If the question that is being asked is about a pre-constitutional treaty, in that case, Supreme Court must answer. In this case, Supreme Court must give the answer, whatever their view is, yes or no. In other matters, Supreme Court may not ask. Let me give you an example. When Dr. APJ Abdul Kalam was a president, he had asked the Supreme Court about the Ayodhya issue. What should be done, and Supreme Court did not respond, because in this case, Supreme Court may or may not respond. But if a question is about a pre-constitutional treaty, Supreme Court has to respond. And in any matter, opinion given by the Supreme Court is not binding. It is not binding on the president. The president can ignore that as well. The Supreme Court is also a court of record. So whatever the Supreme Court says, whatever judgment or whatever argument they give becomes a judgment for the future. Whatever the Supreme Court says becomes a court of law. For example, the Supreme Court, if they say, let's say there's a case in which Supreme Court says, if you have a car in which you have an accident victim and you are going to the hospital, then you are allowed to jump red light. There will be no challan even if you don't stop on the red light because you're going to the hospital. If this is what the Supreme Court says, that will become a law. That will be followed throughout the country. So whatever the Supreme Court says becomes the legal precedent. Apart from this, the Supreme Court also has the power to punish for its own contempt. Contempt of court means if you don't agree or if you don't follow what the Supreme Court says, or if you criticize the court without any information or without any fact, if you keep on saying bad things about the court, if you put allegations that judges don't give good decision because they have taken money, etc., then that is called contempt of court. So if you are found guilty of contempt of court, not following the court's order or making false allegations, then the court can punish you for that as well. The Supreme Court, along with the High Court, also has the power of judicial review. Means, if the Parliament has passed a law or the state legislature has passed a law or executive has given any order, if that order or that law is against the Constitution, if it is unconstitutional, illegal, whatever, the Supreme Court has the authority to strike down the law. That is why you have seen many laws, like let's say Farm Bill or Citizenship Amendment Bill, many of them have been challenged in the Supreme Court. Why? Because Supreme Court has the power to strike down a law if the law is found to be against the Constitution. That is ultra vires. So if the law is ultra vires, then it can be struck down by the court. not just a law, but any executive order of the government as well. There's one more issue about the Supreme Court. Recently, there was a controversy about roster. Now, what is roster? Roster means kind of a schedule to decide which judge of the court will hear which case. There are always so many cases in the court, there are so many judges. Who will decide which case will be heard by which judge? That is a schedule given in the roster. It has been decided that the Chief Justice of India is the head of the roster. The Chief Justice of India has absolute powers to decide who will hear which case, and you cannot challenge his decision. There was a controversy earlier in which Chief Justice of India himself was hearing a matter in which he was involved. But you can't argue that because the Chief Justice of India has complete powers over the roster. The Chief Justice of India is the administrative head of the Supreme Court. In fact, all the appointments in the Supreme Court, apart from the judges, all the clerks or managers in the court for any administration are appointed by the Chief Justice only. So Chief Justice is given complete freedom to run the court in the most efficient manner possible. This brings me to the end of this class number 2 of the Higher Judiciary mini-series. Don't forget to like the video, comment whatever you think about it, share it with your friends who are preparing for the IAS examination, and do subscribe to this channel. If you are preparing for the IAS examination, you can join a lot of courses at 2021, 22 or 23 courses, and also the EPFO revision course can be taken. The IAS course has over 500 live interactive classes, notes, mock tests, and lot more. You have an option of taking the 2021 course, 2022, 2023 courses, and you can also renew your EPFO course as well if you are planning for the EPFO exam. These are the benefits you get of having Gradeup Super: access to all running and upcoming courses, structured study plan, expert faculties, best study material, PDF notes, and a lot more. These are your faculty members. I'm sure you have attended their classes. All of them experts of their own subjects. They have been teaching for many years now. And a lot of new teachers have also joined in recently. Ashish sir has come up as a science and tech expert. We have Nikhil sir, who has also come up recently. We have Mukesh sir, Ashpal sir, Praveen sir, Ajay Mishra sir, Rajiv sir, Deepthi ma'am, Sharad sir. All of these have come in and are extremely talented, and they have been teaching for many years. We are also on Telegram. This is a Telegram channel name. Search for it. You will get a lot of study material and short notes. This brings me to the end of the session, guys. Do join me tomorrow. Tomorrow is third lecture of the mini-series. We will be discussing about the high courts. Thank you so much for joining in, guys. Download the Gradeup app. I will see you tomorrow. Bye-bye, guys.